Thank you for joining us today. My name is Michaela Vrazdova, and I'm a Senior Associate at Scott Legal PC. Today, we are going to spend some time and we will talk about how to obtain a green card based on employment in the US, and we will go over the different employment green card categories. So a few things before we get started. So Scott Legal is a full-service immigration law firm, and we assist individuals pursuing various types of visas and green cards in the US. We can assist with family-based and employment-based and investor-based visas and green cards. And we do regularly process a high number of employment-based green card petitions. We will continue to have this webinar series, and we will have at least 2 webinars a month on different visa topics. At the end of this webinar, we'll send you out a few things. So we will send you out this PowerPoint that will be used during this webinar. We will send you a comprehensive visa guide, and we will also send you a link where you can sign up for the additional webinars we'll have in the future, and also a link where this webinar will be made available. This webinar will also be available on our YouTube channel, and we encourage you to subscribe and hit the notification button on our YouTube channel, as we regularly post immigration videos. And we will also send you a link where you can set up a consultation with one of our attorneys to discuss your particular situation. So regarding panelists today, we are lucky to have Kelly LeGrand Weiner, who is the managing attorney at the firm and who has a vast amount of experience processing different employment green card petitions. And my name is Michaela Vrazdova, and as I mentioned, I'm a senior associate at the firm. And finally, if you have any questions as we go through the presentation, please add them to the chat box or the Q&A box, and we will get to all questions either as we talk or at the end of the presentation. So why don't we get started and just go over, how can you obtain an employment-based green card in the US? So what are the different green card categories? So the first green card category based on employment in the US is called an EB-1A green card. And this is a green card that is reserved for kind of narrow group of individuals who have extraordinary ability in their field, in the field of science, arts, education, business, or athletics. And the standard, what you need to show to the government is that you have risen to the very top of your field. So, the standard for the EB-1A is really, really high. So that's why it's kind of reserved for a narrow group of individuals. And for the EB-1A, you can either have a company sponsor you for this green card, or a big advantage of the EB-1A category is that you can file a self-petition. So you can just basically sponsor yourself, and you don't necessarily need a company or employer in the US to sponsor you. The second category is called EB-1B, outstanding researcher or professor. And to qualify under this category, you must show that you have international recognition for your outstanding achievements in a particular academic field, and you must have at least 3 years of experience in teaching or research in a particular academic field. The third category is called EB-1C, multinational manager or executive. This category is a little bit similar than the L1A, non-immigrant visa, but the standard for this green card is higher, and some of the requirements differ a little bit. So for the EB-1C, you must show that you were employed outside the United States for at least 1 year in the 3 years before you came to the US. And you will also have to show that the foreign entity and the US entity have a qualifying relationship, and both entities, the US entity and the foreign entity, are doing business. And you must be coming to the US to kind of work in either a managerial or executive capacity. The next category is called EB2. So the EB2, there are two subcategories for the EB2 green card. So the first one is called National Interest Waiver. And for this category, the advantage of this category is that the employer doesn't have to go through what is called a PERM process. The employer doesn't have to test the US labor market, and the employer can just sponsor you for the green card if you meet certain requirements. And for the NIW, the advantage of the NIW is that you can also file what is called a self-petition. So both for the NIW and the PERM subcategories, you have to show that you have either an advanced degree, which means that you have at least a master's degree or higher, such as PhD, JD, or that you have equivalent to the advanced degree. And this means that you either have you have a bachelor's degree plus 5 years of post-baccalaureate progressive work experience. If you don't have advanced degree, you could still qualify if you can show that you have exceptional ability in your field. And you would have to show that you meet at least 3 of 7 criteria. And we do have a webinar that goes over the NIW category in more detail. So if you want to explore this category more, we recommend that you sign up for that webinar. And now let's discuss the EB2 PERM subcategory in more detail. So as I mentioned, you must show that you have the advanced degree or the equivalent, which means a bachelorette degree plus 5 years of progressive work experience. And for this EB2 PERM subcategory, you will have to have a US company, a US employer that's going to be willing to sponsor you for this green card. The next category is EB3 green card category. So for this category, you will have to have an employer that's gonna be sponsoring you for the green card. And Kelly will kind of discuss both the EB2 and EB3 categories in more detail. But basically for the EB3 category, you can qualify if you are either a skilled worker, a professional, or under other worker subcategory. So the skilled worker means that the job in the US requires at least 2 years of training of experience. The professional means that the job in the US requires at least a bachelor degree or a foreign equivalent. And the other worker category means that you would be coming to the US to perform unskilled labor that requires less than 2 years of experience. The next category is EB4 category, and this is kind of like a special green card category for various workers, including religious workers. But we'll not discuss this one in a lot of detail, as this webinar will focus on the employment-based green cards. And the last green card category is the EB5 or investment green card. And again, we do have a special webinar that goes over the EB5 green card. So if you are interested in this category, we encourage you to sign up. But basically, the basic requirements are that you would have to invest at least either 800,000 or 1,050,000, depending on where exactly you would be investing the money. You would have to show that the money comes from a legitimate source and the investment is at risk, and the business would have to create 10 full-time jobs. Perfect. So now Kelly will take over and she will go over the EB2 and EB3 categories in more detail.
Thank you, Michaela. Thank you for that great overview. Yes, so we're going to talk a little bit now in more detail about the labor certification process, also called the PERM process. And this is the process that's available for the EB2 and the EB3 categories. And it is the situation that most comes up where a U.S. employer wants to sponsor a foreign national for a permanent visa in the United States. So maybe someone was brought over and maybe they're on an H-1B or an L or an O or an E-2. And at this point, the company wants to sponsor them so that they can get a green card and live in the United States permanently. It's also not required that you be in the United States, for a company to start this process for you. So perhaps you worked for an employer in the past and now you're living abroad and the employer says they're willing to sponsor you for a green card. That's also possible. You don't need to be in the United States to be able to go through the PERM process. So what does this process look like? So this is a company sponsorship process, which means that the company, the U.S. employer, is really doing a lot of the petition in order to make this work. And it's really a three-step process. So the first is the actual PERM, where the end is the labor certification. And there's many steps within the PERM. And the PERM is kind of the longest part of this three-step process. And we'll go over that in more detail. The second step is the I-140. So that's after the PERM has been approved. The company will file a petition with U.S. Citizenship and Immigration Services saying they plan to sponsor this person for a green card. And then the last step is either the I-485, which is the green card petition, or you can also get the green card through consular processing. So let's talk a little bit about the actual PERM process. So within this process, there's kind of many steps that you need to take. One first step is the company has to kind of draft a job description. And the job description, whereas most employers have job descriptions that ask for kind of the ideal candidate, great listener, great communicator, good team player, the job description for PERM can only include the minimum requirements to do the job in a reasonable manner. And the reason is that they want to make sure that the labor market test is as open as possible to potentially qualified U.S. workers. So usually this means that the company needs to kind of work with the immigration attorney to make sure that the job description is PERM compliant, so that it's really only asking for those minimum requirements to do the job in a reasonable manner, as opposed to asking for kind of requirements for an ideal candidate. So once the job description is drafted, then you'll go ahead and file the prevailing wage determination. And this is something that is issued by the Department of Labor, and it will tell you how much the company has to pay the worker once they get the green card in the future. So let's say somebody's here on an H-1B and the prevailing wage comes in and it's higher than their current salary. That doesn't impact the H-1B. The prevailing wage just speaks to what the company has to pay at the time the worker gets their green card in the future. So once you get the prevailing wage, then the company will begin the recruitment process. So this is, also called the labor market test. So this is where the company actually has to place advertisements and has to determine if there's any willing, qualified, and available U.S. workers for the position. If it's a position that is not professional, so not one that requires a bachelor's degree, then the employer has to place advertisements in 3 different locations. So the state workforce agency where the job is located, 2 Sunday newspapers in the newspaper of general circulation, or one of those can sometimes be a trade publication, and then a notice of filing, which is a statement of the job and details about the job that's posted at the actual work site. If the job is for a professional position, so one that requires a bachelor's or higher, then the company also has to select 3 additional, advertisement mechanisms to advertise the job. So, they're all kind of very specific in the regulations. So it's important to kind of work with the attorney to make sure that the advertisements that you place are PERM compliant, because most let's say a company was just already running recruitment, most of the time that's really not going to meet the PERM requirements because there are just very specific timing requirements and only specific mechanisms that actually are allowed under the regulation for this labor market test. So during a labor market test, there's kind of a 30 days where most of the ads are kind of live and active, and then a 30-day, what they call a quiet period. And during that entire 60-day period, the company needs to be reviewing resumes, interviewing anybody that appears that they may be qualified, keeping records of, if people were disqualified, for, why they were not qualified, why they didn't meet the minimum requirements. And then at the end of that process, if the company has not found any willing, qualified, and available U.S. workers, they'll work with the attorney to prepare a recruitment report detailing the results. They'll also work with the attorney to prepare an audit file. So the audit file is important. This is something that the company should keep for at least 5 years or beyond after doing the PERM, because PERMs can be audited, even years after they're approved. So the audit file really contains all that proof that the company conducted recruitment in accordance with the regulations. Something to note, so once you get through recruitment, you prepare your audit file, you prepare your recruitment report, then you file the labor certification with the Department of Labor. And the PERM system is an attestation-based system. So that means that on this labor certification, the company is attesting that they, went through this process, they, did these certain, recruitment mechanisms, and they did not find any willing, qualified, and available U.S. workers. The labor certification can either be approved, it can be, approved or certified, it can be denied, or it could be audited. And if it is audited, then the company generally will have 30 days to provide a response. It's important to note there are some specific audit triggers. So for example, if the job requires a foreign language, that can be a very big audit trigger. If there are requirements for the job, the minimum requirements are outside what the Department of Labor considers normal, that can also be an audit trigger. There's also sometimes just trends, where, the government will decide that they're going to audit, many unskilled worker petitions in that particular year. So always a good idea to kind of touch base with your attorney and determine, does your case have the potential to be audited? It's always a good idea to make sure that the recruitment documentation you have showing you met all the requirements is already in place. So if you do get an audit, you're able to put that documentation together rather quickly to submit to the Department of Labor. So once you get through that process, right now that process can be a multi-year process. So getting the prevailing wage is taking somewhere between 6 months to 13 months for some, some employers. Then doing the recruitment process is at least 2 months, sometimes up to 3 months. Then when you're waiting for the labor certification, that's another 6 to 9 months. You can see that, that entire process can take, 1 to 2 years to even be completed. So that's a good thing to keep in mind when you're planning with your employees. Like, do they have enough time left on their underlying visa? What plans are being made for that? Once the labor certification is certified, then the company can proceed with the I-140 petition. The I-140 petition can be premium processed. So this means that you can pay an additional $2,500 to get an answer within 15 calendar days. At this stage of the process, what has to be submitted is, the company's details about the job, the proof that the company has the ability to pay the prevailing wage, and they need to have that ability from the time they file the labor certification up until the green card is granted. And then you also need to include proof that the applicant themselves meets all of the requirements in the labor certification. So if the labor certification required, a U.S. bachelor's degree, in biology and 2 years of experience, then you have to demonstrate that the applicant has that degree and that experience. So usually for experience, you're going to show that through employer experience letters. They should be, quite detailed. So usually you want to have, even if the company, if HR will only provide kind of the dates and the titles, you want to perhaps also talk to one of your previous managers and see if they can provide an employer experience letter that has that detail that you need. So once the I-140 is approved, then you look to see if the immigrant visa category is current. So that means, is there a green card available to you based on your category? So, for some countries, for example, for India and China, there's pretty long backlogs, for the EB2 or EB3. So you may get your I-140 approval, and then it may be several years before you're able to proceed to this third step. If your category is current, and let's say you're in the United States, for example, on an H-1B, and your I-140 is approved and your category is current, then you can go ahead to the third step and file the I-485 green card application. Once that's filed, you can also file for work and travel authorization along with that. Your family members, so your spouse and your dependent children, so that means unmarried children under 21, can also be included on your green card application. And then this would permit you to stay in the United States, until your green card is ultimately granted. It's also possible, once you get the approved I-140, to proceed through consular processing. And later in the presentation, we'll talk a little bit more about, those two options. All right. So let's talk about some more specifics on the adjustment of status versus consular processing. So in terms of the actual process, if you're choosing to do an adjustment of status, most of the time this is going to be the right option for somebody that, say, has been in the United States on a long-term visa or a temporary work visa. Perhaps they've been in the US for 5 or 6 years on their H-1B. Their entire life is in the US. That's where they live. That's where their children go to school. That's where their spouse works. So in that case, most of the time they're going to file I-485 with US Citizenship and Immigration Services. It gives you the ability to remain in the United States while the application is pending, gives you the ability to file for work and travel authorization. At the end of the process, many applicants will have an interview with the USCIS officer. And then if the application is approved, the green cards will then be issued in the next couple months, usually. A downside or a potential thing to consider with adjustment of status is that once the adjustment of status is filed, for most applicants, it means they cannot travel outside the United States unless they have that travel authorization approved, and that can take many months. There are some exceptions. So for, certain H-1B visa holders or L-1 visa holders, they may still be able to travel on their underlying visa. But let's say that you're here on an O visa, or you're here on an E2 visa. Once you file that adjustment of status, you cannot leave the United States. Otherwise, the adjustment will be considered abandoned. So very important to kind of discuss with your attorney before you do any travel after filing an adjustment of status. Even if you're on H and L, it's really a good idea to discuss with your attorney first, just to understand what you should, bring with you and the discussions you may have at the border when you re-enter. So another option, as opposed to adjustment of status, is consular processing. So, for some people, this might be the right option for many different reasons. Perhaps you need to travel constantly for work. You're in and out of the US every week. It's not, really feasible at all for you to be in the United States and just waiting for the travel authorization to come through. Perhaps you have, business or you have family obligations. So in that case, consular processing may be a good option for you. The way that this works is once the I-140 is approved, that approval is sent to the National Visa Center. That can take, a few weeks, up to a few months. You then complete a DS-260 application and you submit supporting documents to the National Visa Center. They'll review the documents, and once they determine that they have everything that's needed, they'll send the file to the U.S. consulate in the country where you most recently resided. Once the consulate has the capability to schedule you for an interview, they'll send you that notification. You'll attend the interview. And if the application is approved, then you'll enter the United States on an immigrant visa. And then the green card will ultimately be mailed to you about 2 months after you enter the United States. So these are kind of the two options available to you after you get that I-140 approval and after there's a green card, once your green card category is current. All right, so this is a common question we get. So wanted to address this, who can pay for the green card fees? So it's very clear in the law that fees related to the PERM process, legal fees, and any other fees have to be paid by the sponsoring employer. Additionally, it's really, sometimes people come to us and say, well, the employer said that they'd pay, but I have to sign a contract that says that I will be, reimbursing them for everything. So that is not permitted. It's like for the PERM process, the employer has to pay. When it comes to the I-140 immigrant petition and the green card petition, there's more flexibility. This can be paid by either the employer or employee. So let's say, for example, your employer agrees to pay for the PERM and the I-140, but then you want to premium process the I-140 and they don't. If they're agreeable, you could pay for that premium processing fee to get the answer within 15 calendar days. Additionally, for dependents, that's something where either the employer or employee can pay. All right. So in any kind of scenario where you're thinking about applying for a green card, it's a good idea to think about intent. So some non-immigrant visas allow for dual intent, meaning that you are permitted to, have this temporary visa and also intend to immigrate permanently to the United States. So the clearest dual intent visas are the H-1B and the L. It's very specific in the regulations that these are dual intent visas, that you're permitted to actively have a green card petition pending and also be on these temporary visas. We have O listed here. O, I would say, is more kind of a quasi dual intent visa in the sense that there's some supporting language in the regulations that indicates just having an immigrant petition pending or approved doesn't prevent you from getting that visa. But it still doesn't have, it's not as clear as with the H-1B or the L. And for the O, you don't have that same benefit where once your adjustment of status is filed, you can't travel on the O, you would be abandoning your green card application, whereas that's not the case with the H-1B and the L. So, other visas that you may be on, let's say you're on a TN visa, and you have an immigrant petition pending or an E2. So I think intent is always important because you want to consider, when is the immigrant petition being filed? And will that have any impact on your visa renewal if you're in a situation where you do need to renew, your visa while this green card process is ongoing? So it's always important to have those conversations with your employer and the attorney ahead of time. For example, let's say you're on an E2 employee visa and you're in a position of needing to renew that visa for another 5 years. And also, your labor certification was just approved. You may decide it's better to get the E2 renewed and then proceed with the immigrant visa petition after that renewal has already gone through. So those are just the type of strategy, conversations you want to be having with your attorney before you kind of proceed with filing, they proceed with filing an immigrant visa petition for you. All right, so let's talk about some considerations when you're moving from a visa to a green card. So timing and your underlying visa status. How much time is left on your underlying visa? As kind of I was just discussing, some visas are harder to extend or are subject to more scrutiny once an I-140 is filed or a green card petition is filed. Some visas like the TN visa, for example, really would be very, very difficult to renew. If you'd gotten to a certain part of the green card process, if you're in a situation where you have to go to the border and an officer asks you about it, or you're at a consulate and the officer asks you about your plans with an I-140, and let's say you filed an I-140 and indicated you plan to adjust status in the United States, you've indicated your immigrant intent. It's that intent is out there. Although you can argue that, decisions may change, you may decide to consular process, you may decide not to proceed with the application. It's just another risk factor in the application. So not to say it would 100% be denied, but it would absolutely be a big risk factor for a visa like the TN that does have a pretty high standard for proving that you do not have immigrant intent. Other considerations, in terms of that underlying status is kind of, your ability to continue working without interruption, right? So always best to keep that underlying status if you can. If you are able to file an adjustment of status, then you can also file for work and travel authorization. And if you needed to, you could switch to that employment authorization card. But if you are able to maintain that underlying status, for example, H-1B or L, then that is, better, gives you just a little bit more certainty. That way, if you're on an H-1B, let's say, and your adjustment of status is denied for some reason, you still have that underlying status. You're not having to leave the US right away. So another thing to consider, do you want to adjust status or do you want to get your green card through consular processing? So as just discussed in the previous slides, you want to think about, will you be able to stay in the United States for a long period of time without travel, or was that not feasible for you? Is it easier for your family to attend an interview at a consulate, or would it be better for them if they were able to just stay in the United States while this application was pending? So all good things to consider. In terms of your family, you want to think about, do you have children and you want to get them that green card? If so, you want to talk with your employer, kind of early on about filing for the green card, because it can take several years and, your children will eventually age out, if they get married, if they can only be part of your petition as long as they're unmarried and under 21. So always a good thing to consider, in terms of planning. All right, so, you've made it to the last step. You've kind of gotten the labor certification approved, the immigrant petition, the I-140 is approved, and now you're going to, to the green card interview. So what are some important things to consider when you're preparing for this interview? So one is you want to review the immigrant visa petition and the green card petition before the interview. So the immigrant visa petition is going to contain kind of details of the job offer. It's going to contain details about your, work history, how you meet each of the requirements. And then the green card petition contains more kind of biographical information about you, your children, your spouse, if you had any kind of criminal issues, any security issues, all that would be flagged on the green card application. You want to organize and print documents to bring to the interview. The interview notice is generally going to contain a detailed list of what they want to see. You want to bring your original documents and copies of those original documents. So birth and marriage certificates. You want to bring a sealed medical exam if you haven't mailed that ahead of time. Also a good idea to get updated proof of employment from the sponsoring employer. So, sometimes it can be years between the time that, the PERM is approved and the green card interview happens. So they do want to see those updated documents from the sponsoring employer, just showing that the job offer is still open and that the job offer still meets those requirements, as outlined in the labor certification. If you are adjusting status as opposed to at a consulate, you also should bring proof of your maintenance of status. So that means that, they could hypothetically question you about any potential entry in your entire immigration history. So if you're in a situation where perhaps you were out of status even for just a couple of days in the past, it's something you really need to discuss with your immigration attorney. Luckily for most employment-based applicants, they're able to take advantage of something called, 245K, which is something in the regulations that exempts employment-based applicants from being unable to adjust status, based on, if they can meet certain parameters. So always really important, though, to discuss your detailed immigration history with your attorney ahead of time, just to make sure you're prepared to answer any of those questions, at the green card interview. So along with that, you want to kind of meet with your attorney, do a practice interview. Very often, you might be nervous on that day. So you want to just get a sense of how you would respond to these questions, to try to give you the best chance of success at the interview, and make sure that you're flagging any, potential areas where they might ask additional questions. Definitely if you have any criminal history, if there was any time out of status, any unlawful presence accrued, if there was any military history, these are all things that can come up, at the interview. Let's talk a little bit about porting. So this is something I think that also, because the green card process can be so long and people are, proceeding in their careers, it often comes up that they may want to change employers. And particularly if your employer is undergoing the green card process for you, it's very important to know what impact will this have? Will you be able to continue in the green card process, even if you change your employer? So, ultimately, let's say that your employer has just filed a PERM, started the PERM for you. They've just filed your prevailing wage determination, and now you move to a new employer. You really retain no benefit from kind of the fact that another employer has started a PERM process, for you. There's really nothing you can kind of take, to the next process. Let's say you've even gone as far as an I-140 has been approved for you. So that can have some benefits, particularly if you're on an H-1B and you're in a situation where your category is not current. You can potentially get 3-year extensions on the H-1B based on that approved I-140, as long as it wasn't revoked within a certain time frame. But, in terms of changing employers and retaining kind of most of the benefits of the green card process, that doesn't really happen until your I-485 has been pending for at least 180 days. So let's say that you have an I-140 approved, your I-485 has been pending for, 180 days. Now at this point, if you wanted to port to a new employer, that new employer would not have to do the entire PERM process over for you. What they would have to do is demonstrate that you're porting to a new job that's in the same or a similar occupational classification as was approved on the PERM application. So you would need to submit, a different form, I-485J, to USCIS, informing them that you're porting. You would need to submit evidence showing that it's in the same or a similar occupational classification as the labor certification was approved for, but it does give you that ability to change employers without the employer having to do the entire PERM process over. However, that you need to make sure you're at that stage of the process. So another common question, can I change employers after I get my green card? So when you obtain your green card, you and the employer are each making good faith attestations that, the employer is saying, we intend to employ this person in this job, permanently in the United States. You as the employee are saying you intend to, work at this job permanently in the United States. So, that's to say that getting your green card and then quitting the next day, the optics of that are not very good. In the future, if you, go through the naturalization process to try to become a U.S. citizen, the officer may look at that history and ask questions about kind of what was your real intent, why did you leave the job so quickly? And there may be reasonable explanations for that, right? You may get your green card and then perhaps, your spouse is transferred to another state, or there may have been then layoffs at the company. So many different things could happen that could explain why you change employers, but ultimately, can you change employers after you get your green card? Yes, but it is a good idea to remain with your employer, at least for, I'd say, several months. And when you leave, there should be an explanation for why you're leaving, as, you want to avoid any, anything that would indicate that there was a misrepresentation on your part in getting your green card. All right, so we've reached the end of the presentation. See if there's any questions that came in. I think there's just one question here. Somebody who's on a TN visa and asking about applying for EB2 or EB2 NIW. So in terms of, this type of question, I would encourage you to set up a consultation with us so we can go over your specific background and provide, advice based on your particular circumstances. Because assessing for, the eligibility is going to be kind of a longer process than we would provide in this presentation. I see someone's raised their hand. If you'd like to send in a question, we can answer it. Otherwise, I think we are, I'll give you a few seconds to do that. Otherwise, I think we will close.
Thank you so much, Kelly. And thank you everyone for joining us today. And we'll send you out all of the things I mentioned in the beginning.
All right. Thank you. Have a nice day.
Bye.